If you've been watching the news, then you know that our voting rights are under attack. And this week was no different. In Louisville, Kentucky, home to over 600,000 people, but also home to half of Kentucky's black population, there was only one polling place. This led to unreasonably long lines, and some people were shut off from voting as early as 6 p.m. What we've seen is a concerted effort nationwide to roll back voter protection, and that includes weakening the Voting Rights Act of 1965. The Shelby versus Holder case of 2013 played a huge role. Its decision helped to roll back over 50 years of voting rights progression. But in order to know the full story, you have to go back to the beginning. In the period after the Civil War, the 15th Amendment was signed, which was supposed to grant all freemen the right to vote, but we all know better than that. In especially the South, black votes were suppressed for an extra 100 years. Whether by poll taxes or literacy tests, every measure was taken to prevent black people from voting. There were even tests to guess how many jelly beans were in a jar. And of course, there was the domestic terrorism, undertaken in order to intimidate and deter our community from voting. Through the work and sacrifice of so many, the Voting Rights Act of 1965 was signed, and one of its major provisions was Section 5, which required certain states and local governments with a history of voter suppression to obtain federal preclearance before implementing any changes to their voting laws or practices. A coverage formula provided in Section 4B would determine which states were under this jurisdiction. Well, in April 2010, Shelby County, Alabama, filed suit asking a federal court in Washington, D.C. to declare Section 5 of the Voting Rights Act unconstitutional. Section 5 was upheld by the D.C. Circuit Court and Appeals Court, but the case was then heard before the Supreme Court, which struck down Section 4B, which in turn stripped Section 5 of its power. The court voted 5-4 along conservative and liberal lines, with Chief Justice Roberts joined by Scalia, Kennedy, Thomas, and Alito in the majority, and Justice Ginsburg joined by Justice Breyer, Justice Sotomayor, and Justice Kagan in the dissenting opinion. The Shelby ruling released 9 states: Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia from government overview, and also affected some counties and townships in California, Florida, Michigan, New York, North Carolina, and South Dakota. This has led to increased voter suppression laws, including voter ID laws, as the rights of black, brown, young, elderly, and the poor are under attack. As you can see, our voting rights are under attack daily, and we're in the fight for our lives in November. So what I need you to do is to register to vote, and register your family and friends to vote as well, because we're going to need all hands on deck. If we want to strengthen the Voting Rights Act back to what it needs to be, we're going to need a president that can put forth nominees and a Senate that can vote them through. We have to vote because justice and law will be on the ballot. The Supreme Court is up for grabs. Vote because your life depends on it.